I got one question. How did your semen end up in her panties?
I don't know, sir. I have no idea. But they found no evidence and no probable cause to press no charges. So I
Oh,
don't know
she
what's going. I
passed
didn't know
away.
what happened, sir.
Okay, no further questions.
Oh, that is a mistake. You don't want to just. I don't know how that got there at his parole hearing. He's serving a 75-year sentence. He's 23 years into that. And this parole hearing, it is like an onion getting peeled layer after layer. It gets deeper and deeper. We'll unpack it with the details at
Mr. James, we find that you're a first felony offender. You're currently serving a 75-year sentence for armed robbery. You have a parole eligibility date that was 11/9/2001. This is a rehear. You have good time date of 7/22/2031, and you have a full-time date of 11/9/2056. Does that sound correct?
Yes, ma'am.
Sir, at this time, we'd like to ask you, why do you think that we should parole you today?
Yes, ma'am. I believe, I deserve a second chance and I've rehabilitated myself, ma'am. And I apologize. And I wrote that a program years ago where you could write letters and give it to the designated warden at the institution, and he would take it and pass it on to the victim, the Baton Rouge, and Baton Rouge would pass it on to the victim. And I truly apologize. I know I did something wrong. I just, I just asked for a second chance, ma'am. And I know I hurt the family, because I hurt my family too. Because when I do time, they did time, and I apologize to that family, ma'am. And I just, if there's anything else I can do to make up and do better, and I'm gonna do better, ma'am. And I apologize to them very much, ma'am.
Okay. We'll be asking you some more questions. Deputy Warden Turner, do you have any comments you'd like to make?
Yes, ma'am. I can probably sit here all day and talk about the type of inmate that Ronald's been since he's been at DCI. From the moment he got off the bus, he's been a respectful inmate. We've never had a problem with him. I think his last write-up was over 17 years ago. He does everything that we ask him here. He works real close with myself. He works real close with the inmate population. He works real close with the other administration here. And he's one that we can always go to when we have issues or concerns and get suggestions and recommendations from him as how we can be better supervisors here, how the administration can improve the facility. And he's just been an awesome inmate. And I think if the board would give him a second chance, I don't think we would ever have to worry about him again. He's been a tremendous inmate, and he's been a real respectful inmate his entire time here at DCI. And I definitely appreciate him. I wish there were more inmates like him.
Thank you for those comments. We also have the Mr. Rapidoo.
He's not.
Not going to be on, sorry. So at this time, your case has been assigned to Mr. Barra, and he will be taking the lead and asking questions.
All right, Mr. James, I just need to get a couple of facts in the record first. And basically, on November 9th, 81, you were selling magazine subscriptions door to door and sold a subscription to LMA Monroe and left. And then you returned a short time later and said you were there to correct paperwork, the address on the paperwork, and then asked to use the restroom. When you came out of the restroom, you wrestled with Ms. Monroe to the floor, put a knife to her neck, and threatened to kill her, sexually assaulted her, and then took $85 from her purse. That's what we see as pretty much the facts of this case. I also see that although you're a first offender, you've been arrested 11 times for 15 different offenses, and 7 of them were crimes against the person. And specifically, I'd like to ask you about 2 charges in Kansas that it looks like one of them was dismissed, and I don't know why. I was gonna ask you why. And the other one was dismissed due to the witness being deceased. So on 8/4/77, August 4th, 1977, in Kansas, you had got arrested for a rape charge. What happened there?
Well, I was in Kansas at the time, a town called Junction City, Kansas. And it was a young lady that was living with me by the name, I remember the name, girl, Cheryl. And we had a disagreement. And I didn't agree with what she was saying, and she didn't agree with what I was saying. And then the sheriff, the lawyer was named, the sheriff was named Mr. Stephen Opak, I believe, if I remember correctly. And she went to him and she got him to file charges against me. But we did wrestle, sir. But what the assault didn't happen, so she put that part on. But we did wrestle. And Mr. Stephen Opak didn't see nothing fit in it. And so he dismissed the charges, sir.
Okay, and then, so that was basically a disagreement between you and your girlfriend that she put charges on you and then ended up getting denied.
Yes, sir.
All right, what was the second one with the rape and the armed robbery?
Okay, sir. When I
That was-
went back,
25th, 81.
yes, sir. When I went back to that house, sir, to get the paperwork, to straighten the paperwork out, sir, that lady said, "Oh, you came back here to ravish me?" I said, "No, ma'am." She said, "Yes, you did. You come back here to ravish me?" I said, "No, ma'am, I did not." I said, "I come back here to straighten up the paperwork because I forgot to put your name and your address on it." And then I got arrested for it. And when I went to the county jail, I stayed in the county jail. I had the armed robbery charge and the sexual charge. And the sexual charge it was dismissed for no reason. I don't know what happened, but it was dismissed. And I was charged with the armed robbery only, sir. And I was given the 75 years that I have now, sir.
Right.
You know,
You're talking about the current charge that you're in for with the magazine. And on that charge, there was no semen found on her, but there was your semen found on her clothes. And the doctor's impression was there was a forced intercourse, whether you got charged with it or not. That's the end of that report. But what I was just asking you about is the one that happened in Kansas, the second one that happened in Kansas.
okay, sir. Mr. Stephen Opak, the sheriff, they didn't find no credible evidence in that trial, and they dismissed it, sir, because I can say it didn't happen, but they didn't find no credible evidence, sir.
On both of the ones in Kansas.
Yes, sir.
All right. I see that you took some classes, inmate classes in 2010 and 11. Then you went on a dry spell until 2024, where you took another class enrolling in pre-release on 7/15/24. Am I missing anything right there? Did you do anything in between 2011 and that one class in 2024 that I don't see? Besides the certificates, I'm about significant classes where you get good time credit. I see you had a lot of certificates.
Yes, sir. Well, I was a facilitator for character count for Mr. Duvall. He had DCI. Then when the pandemic hit and then it came on, we kind of like straightened a little bit. Then I already had the good time that I could earn, and I already had the certificates for the other classes. And I wouldn't go back and take them over because I know I couldn't get no more good time for them. That was the maximum I could get from that.
So did you take victims awareness?
No, sir, I did not.
Did you take thinking for change?
I can't say that again, sir.
You take thinking for change.
No, sir.
And did you take any sex offender classes at all?
No, sir. No, sir, I did not.
Okay, those would be recommended classes for a guy in your situation, just to let you know about that.
All right, sir.
So tell me about the day that the magazines were sold. How did that go down? What's your, you already said part of it just now, but you were selling magazines and then what happened?
And I went back to correct it, a date, a name on the receipt, and then
Uh-huh.
that's when she said, "Sir."
I'm listening.
Oh, and that's when she said, "Oh, you came back here to assault me. You came back." I said, "No, ma'am, I did not. I came back to correct the receipt, ma'am." I said, "No, yeah, you did. Yeah, you did. Yeah, you did." Then I asked her, I said, "Would you let me use your bathroom?" And I used her bathroom, and that was it, man. That was it, sir. And I left. I corrected the date on the receipt and I left. If I remember correctly, sir, I think it was a TV guide on that receipt.
Okay. That's all the questions I had for you.
Thank you, sir.
Were you living in Louisiana when you were selling magazines?
No, ma'am.
Where were you
I-
living and why were you selling magazines 36?
We were going from state to state selling magazines. I was traveling with a company called Chapel Sales out of New Jersey. And we was just going from state to state selling magazines, books and encyclopedias and Bibles and geographics and stuff like that.
I just got one question. How did your semen end up in her panties?
I don't know, sir. I have no idea. But they found no evidence and no probable cause to press no charges. So I
Oh,
don't know
she
what's going on. I
passed
didn't know
away.
what happened, sir.
Okay, no further questions.
At this time, we are gonna be prepared to vote, Mr. Buffer.
Well, Mr. James, based on your criminal history of convictions and arrests, today I have to vote to deny parole because of the violent nature of this crime, the opposition from law enforcement, there's strong law enforcement opposition here, and the victim's family is strongly opposed. And for those reasons, I have to vote to deny parole today.
Mr. Freeman?
After what the warden said, I was sitting here and saying, I'm gonna base it totally on his interview. But when they got your DNA in her underwear and then you go still sit there and tell me nothing happened, can't do it. So my vote is to deny.
Mr. James? Wow, you have so much going for you in terms of your support from the warden and your respect in the facility. To be honest, I concur with my colleagues. I want to see you take a few more classes. And
Yes.
denying your involvement is not in your favor. Okay, and you're facing 75-year sentence. You've done 32 years. My vote is to deny, but I'm going to encourage you to continue down the same path. Okay. Thank you very much. Today,
Yes, ma'am.
your parole has denied, and you will have the opportunity to write back. The time is 12:02. Warden, if we don't have any other business that you know of, we're going to go ahead and conclude our hearings today.
Thank you, ma'am.
Wow, so he was denied, but keep in mind he has a good term date of 2031, so not that long, 6-7 years, and he'll be out anyways. And he's served a long time, but it's hard to root for him when you find out how long his record is, how extensive it is. And we'll go through some of that information, but it's scary. And I feel like the warden, we haven't seen him before. Normally we have another warden, which I like to call our favorite warden, but it seems that this warden also has a problem with this poker face. I wouldn't be surprised if he actually didn't know the details. Remember, for whatever reason, they only got him on armed robbery. So here's a man who he thinks, well, he's 75 years for armed robbery. He's a good guy, no write-ups. He's a stand-up guy. I'm going to give him a great review. And then he finds out through this parole hearing that he's a serial offender. He has multiple sexual assaults. We'll go through that. It's unbelievable that he was even out to commit this offense. And then he denies it to Mr. Freeman. I don't know how that got there. I mean, and I'm sitting here just like flabbergasted. Why are you denying it? The warden, I think he's looking at him like, what are you saying, denying it? But maybe, he felt like it's not in his jacket. The court didn't convict him for that. But the parole board, give them credit. They do their homework. They do their research. They ask the questions. And, compared to the other states that we cover, check out channel 2 in the description below if you want to see it. They don't care. Most of the states, they don't do their research. He'd be out a long time ago. But it's scary to think he's out because he really is a serial offender. So in 1983, he was convicted. On November 9th, now here's the time of the crime. On November 9th, 1981, the defendant was canvassing West Hutchinson Street in Louisiana, attempting to sell magazine subscriptions. For this purpose, he and a fellow worker entered the home of Ella. At approximately 8 p.m., the two remained inside the house to close the house close to a half hour, during which time Ella purchased a subscription to TV Guide magazine. The defendant later returned to Monroe home ostensibly to record an address on her copy of the receipt. After the victim was unable to locate her receipt, the defendant left momentarily. He then re-entered the home, grabbed her, held a knife to her throat, threatened to cut her. The victim testified that the defendant took $75 from her at the time. And again, I don't know why they didn't charge him for the other offenses. I just don't know. But DAs were weird like that. And we'll go through more of the information. So let's continue to scroll down. I like Mr. Freeman's mic drop. He's like, okay, I'm done. And he's like, I was going to probably grant based off of what the warden said on your hearing. And man, he couldn't have done it worse. Also, what did he say? I know they're hurting. My family's hurting too. That's just a classic line that we hear so often. This is a pretty good appeal. Thank you, Richard, for finding it. It actually has a lot of information. We won't go through all of it. But let me go down to the part where they talk about his record. It seems that he actually had left a confession, which they argued too, in this hearing. And he took the stand. Which we know is never a great idea. During cross-examination of Captain Richard, defense counsel questioned him concerning a report of the crime lab, which indicated no fingerprints were found on the alleged weapon used by the defendant. On redirect examination, the prosecuting attorney asked the defendant, "Does it surprise you that there are no fingerprints on the knife?" Defense counsel objected, stating, "I would object to this questioning. He is on direct examination." By this statement, it would appear that the basis of the defendant's objection was that the prosecutor was asking leading questions to his own witness. The basis for the objection was not that the question called for opinion. Thus, the defendant appears to be raising a new basis for this objection in his brief. A new basis for an objection cannot be raised for the first time on an appeal. I'm frankly not so sure what they're talking about with the basis of the first. Okay. The next allegedly improper questioning arose when the prosecuting attorney asked the witness What percentage of time do you find prints on a weapon? The defendant objected to this question, stating that it called for an expert opinion. The trial judge overruled the objection, allowing the witness to testify based on his own knowledge of cases. That makes sense to me. This ruling appears to be correct. And they give the reference. The witness responded that in 14 years, only 3 cases have been made with fingerprints. As this answer appears to have been from the witness' personal knowledge, it is not objectable. Isn't that interesting? That the only 3 fingerprints. Then they talk about maybe the fingerprints were wiped. Why was it dusty? How could it be? They're basically trying to prove that there's no DNA evidence. You can't, not DNA, no fingerprints. You can't. And this day and age, if you might have that argument about DNA, you might say, hey, there's no DNA on the knife. It couldn't be him. That's certainly what defense attorneys try. Now let's talk about where they go over his prior record, which the judge allowed into to be used in court. And it's scary when you hear about this record, and they brought it up. The pre-sentence investigation report made part of the record show that the defendant had a long history of serious criminal activity between 1977 and 1981. The defendant was arrested for and charged with numerous offenses, including 2 sexual assaults, an armed robbery, 2 counts of simple burglary, possession of a deadly weapon, aggravated battery, possession of stolen property, attempted escape, and this is the worst one, possession of the devil's lettuce with intent to distribute. The report also revealed that the defendant stands charged with aggravated sexual assault of the victim in this case, which allegedly occurred during the armed robbery. And I don't know why. Was he not found guilty of that? But again, this is a big problem in these cases where, for whatever reason, he's not found guilty. The DA doesn't prosecute it. Well, I mean, if he's not found guilty, not found guilty. That's the system. But if the DA chooses not to prosecute it, drives me nuts, because then you have a situation like this where it's only in his jacket that he just did armed robbery. But and you really, all you do is ask, how was he out? He had all of those arrests and he's still out to do this again. What is going on? It blows my mind. In light of the defendant's history of criminal activity, in particular his record of serious crimes against the person, we find no abuse of the trial court's discretion in the position of a 75-year sentence. This assignment lacks merit. For the above and foregoing reasons, the defendant's conviction and sentence is affirmed. And there you have it. Now he's been locked up a long time, but he's going to get out in good time in 6 years. Maybe we'll see him again for parole. Anyways, help the channel reach 100,000 subscribers. Click the button, and with that, I'll let you